My guest for this hour, criminal defense attorney and former assistant state attorney and the attorney for Jussie Smollett, Tamara Walker. Tamara, thank you so much for being on the show tonight. Truly appreciate it.
Hi, thank you for having me, Michael.
All right, let's begin with your reaction to this verdict. It shocked us all, 2 hours and 38 minutes. Not the ultimate outcome of the verdict, but the fact that it only took 2 hours and 38 minutes.
Yes, that was definitely a quick verdict, and generally that is not good news as a defense attorney. So what struck me here is Mr. Edgecomb's testimony himself. I think that he did not do himself a lot of favors on the stand. There were a lot of effective points made on cross, particularly attacking part of his excuse of leaving the scene and, leaving the state for several months after this incident because he couldn't find lawyers when he had lawyers already. So I think he just didn't do himself a lot of favors on the stand, unfortunately.
Yeah, absolutely. Do you think he might have been better off if he didn't take the stand? I thought there was plenty of evidence here for this jury to determine whether this was self-defense without him taking the stand. But again, it is a self-defense case, and there's almost an expectation that the defendant tell his story.
That's exactly right. That is one of the most difficult decisions to make as a defense team, as I'm sure as the defendant himself, because you don't know. You put so much into defense of a case, and that is one of the most key critical decisions. A lot of times you have clients that just really want to tell their story, and sometimes they're the only one who can. Whether it's beneficial to the case or not is always a huge question mark.
No question about it. Now, the supporters outside the courtroom had made this comparison between the Rittenhouse trial, saying that they were hoping that a black man could get the same kind of justice. In your estimation, do your best to compare those two cases and whether you think this was, in fact, a just result when considering what happened in the Rittenhouse case.
Well, I look at it two ways, and I'm glad you asked that question, Michael. I look at it like this. I think that, Edgecomb's testimony confused the jury when he got into the fact that it was an accident. I think it could be painted in a way, but it's difficult to reconcile that with the self-defense. Whereas Rittenhouse's presentation was always very clear. I think prior to Edgecomb making the accident distinction, that absolutely, and I've drawn the comparisons on this show. So I think absolutely prior to him saying it was an accident, definitely a fair comparison. But with him, going so far into the accident territory, when you also have an affirmative defense of self-defense, those are two difficult things to say.
Yeah, they're tough to reconcile. There is a way. My previous guest talked about the fact that, he had argued before in a case that a defendant pulled the gun out as a way of sort of stopping whatever they were facing. And then ultimately, that was part of the self-defense, but that the gun went off and that was accidental. But that wasn't the approach from the beginning for the defense. So I thought it might have been something that came out of the blue. I don't think it was part of the defense's strategy. What effect do you think it ultimately had on the decision by this jury? Because they didn't go for the intentional murders. They went for that reckless homicide, which again includes recklessness and this extreme indifference to human life.
Well, I heard in your lead-in that you said it may have played well for Edgecomb that he did take that tactic. I would agree that it did not seem to be a part of the defense strategy. It seemed to be something that they were not expecting, which happens all the time. So I think that here it may have been the difference between first-degree conviction and what he was ultimately convicted of. But here's the thing. Here's what's going to keep everybody up at night. Had he gone with the self-defense argument in the way the defense laid out, would it have been a not guilty? Also, had they worked in, as you said, the accident along with the self-defense, would that have been a not guilty? Those are the kind of questions that drive us crazy as defense attorneys. So
they do, but I'll tell you, Tamara, when I look at it, and certainly I've asked that question of myself of this case, I don't think they bought the self-defense. I don't think they bought the self-defense at all. And I think without that opportunity, I think they would have ended up coming back with one of the intentional murders. Now, there were other options. So if they didn't buy the intentional part of it, they could have come back with some of the lesser includeds. But I don't think they bought the self-defense at all.
I think this case had so much evidence that, again, when the defendant puts himself on the stand, makes himself a witness, makes his credibility an issue, makes, the jury have to focus on him, it's always a risk. I think that I agree with what you said earlier. There definitely were, circumstances that were present. You had the victim's alcohol level. You had the prior incident before the video picked up what occurred. You had the aggressive manner in which the wife was following Edgecomb. There were a number of things that I think played well. It's just a nuanced distinction, and ultimately you never know what's on the minds of those 12 people.
Absolutely. At some point, hopefully, maybe one will speak out and let us know exactly what went on in that deliberating room. It would certainly be fascinating. All right, Tamara Walker, stand by. We're going to take a break right now. Still to come.